Welcome to Disunion, the Government Union Report, the podcast where we delve into the ever-evolving landscape of public sector labor policy and law. I'm your host, David R. Osborne, and I'm excited to be your guide through the complex world of government unionization. We bring in experts and individuals with hands-on experience navigating the challenges and opportunities surrounding the unionization of government employees. From the latest legal developments to the practical insights that shape the policies, we've got it covered. So get ready to gain a deeper understanding of the news-making issues that impact public sector labor policy across the nation. I'm joined here today by Bill Messenger. Bill Messenger is Vice President and Legal Director of the National Right to Work Legal Defense Foundation. He's got a long career already litigating He's got a long career already in which he's litigated important cases that involve both private and public sector unions, and more specifically, the extent of individual rights in the context of public sector unionization. So 3 of these cases went all the way to the Supreme Court, and 2 of them together, Harris versus Quinn in 2014 and Janus versus AFSCME in 2018, constitute the court's most recent pronouncements in that area. Bill, thanks for joining me.
Well, thank you for having me on. I appreciate it.
Yeah, well, I wanted to talk a little bit about those 2 cases in particular and what they've kind of meant to the area of law. But I thought probably the best way to attack that would be to review a little bit of history and talk about the case that basically those 2 cases had to contend with in order to become, existing law, what they are today. So there's a case called Abood versus Detroit Board of Education, 1977. And of course, you're more familiar with it than anybody because you had to stand up and talk to a bunch of Supreme Court justices about that case. Tell us what was happening before Abood. What was the state of the law before Abood came about?
Sure. So it actually started in the private sector. So starting back in the 1930s, you had what's called a compulsory unionism clause, also sometimes called a union security clause, something to that effect, agency fee clause. And basically what it said is anyone who works in a unionized workplace has to pay dues to the union or you're fired. So if you worked in a factory and it was unionized, you don't pay dues to the union, you lose your job. However,
does this appear in a collective bargaining agreement, or is this something that somebody would sign? Okay, so it's in a collective bargaining agreement that, a steel worker might come to work one day, ask, can I get a copy of that collective bargaining agreement? And he would learn at that time, perhaps, or when he first met with a union representative, that he has to pay union dues as a condition of his employment in the steel factory.
Yes. So as authorized,
sound right so far?
Yes. So as authorized under federal labor law governing most private sector employees, there's a 30-day window. You either have to join the union or agree to pay union dues within 30 days of employment, or you can be terminated. Now, that isn't true in all states. There's what's called right to work states, which have state laws that say these compulsory unionism provisions are prohibited by state law, and that every worker has the right to choose whether they want to join the union or not join the union. However, in forced fee states, like, for example, New York or California, you had these compulsory unionism agreements that forced all the employees to pay union dues. And they started from the 1930s and continue to this day in the private sector. But moving to the public sector, that's a more recent phenomenon. It's sort of hard to believe now, but before the 1960s, public sector employees were almost never unionized. But starting in Wisconsin, I believe it was the late 50s, they came up with the idea, well, if you can unionize private sector employees, why not impose the same thing on public employees with respect to their dealings with the government? So this sort of caught on in the 1960s, and you started taking this labor model, which was previously applicable to the private sector, and applying it to public sector. So all of a sudden what you had is, in order to become, say, a teacher in the state of Michigan, you had to pay dues to a union or you lose your job as a teacher. Or to become a public servant in Illinois, pay money to the union, or you can't be a public servant in Illinois. And so that application of compulsory unionism brought up some issues.
So, sorry, I spoke a little bit with my wife's grandmother about this. She was a teacher in New York and saw the unions come in. I suppose it was in the 60s or early 70s, something like that. And the unions came in and basically imported much of the private sector mentality into the public sector. She found it odd, not necessarily distasteful. She may have been a union member for all I know, but found it odd that this sort of blue collar, factory worker mentality was coming into the school system. And I suppose what you're saying is part of what they brought with them was this agency fee model whereby any employee would have to pay union dues to keep their job. So it was kind of foisted upon the public school system.
Exactly. Yeah, they took that private sector labor model and imported it to the public sector, which really creates some odd bedfellows because, forcing employees just to accept a union representative for dealing with the government, all of a sudden, that's really political representation. I mean, because if you join an organization for the purpose of influencing the government, that's a special interest group or a lobbying group. And so all of a sudden importing that union model from the private sector in, basically you're forcing teachers to accept a designated lobbyist or special interest group for purposes of lobbying the government on their behalf. And with compulsory fees, then you force the employees to pay for that political representation. So it's always been a very odd fit taking this private sector labor model, which had its own problems on its own, and then importing it into government and into an individual's relationship with the government.
Yeah. So then Abood came about, and how did Abood change that?
Sure. So Abood arose out of the Detroit school system, and Michigan unionized public school teachers, and the Detroit Board of Education basically said, if you want to be a teacher in Detroit, you have to pay full union dues across the board. The Michigan Supreme Court actually upheld that and say that's perfectly fine. You could force people to be full union dues to be a public servant. And then the Supreme Court ultimately took that case. And the issue there is whether that violates the First Amendment, because there's very serious constitutional problems with the government forcing a citizen to pay money to a special interest group for purposes of lobbying the government. And so that was the argument in Abood, is that kind of a compulsory fee, that's compulsory speech or compulsory subsidization of speech, and that violates the First Amendment. And one thing that should have strongly supported at the time was a case called Elrod. It was decided at the same time. It's worth talking about for a minute just to draw the parallels. The issue in Elrod was literally whether or not public employees could be forced to support a political party as a condition of keeping their job. So, for example, to be a public servant in Illinois, you had to be a Republican. Otherwise, you're out the door. It's a spoils system for those of us who can remember, high school, history classes. The Supreme Court in Elrod, same year as Abood, said that's unconstitutional. You can't compel individuals to be part of a political party, to support a political party in order to have a government job. And so the hope was in Abood, they'd apply that same logic there. Unfortunately, in Abood, that hope was dashed. The Supreme Court sort of split the baby. And what the Supreme Court did, it took the private sector labor model, and under the private sector employees can be forced to pay union fees for collective bargaining, grievance adjustment, things like that, but couldn't be forced to pay for political expenses and lobbying. That was sort of the line drawn before Abood in the private sector. Abood, the Supreme Court there, took that model and said, we're going to apply the same thing to the public sector. Public sector employees can be forced to pay the union for its cost of bargaining with the government, administering a contract with the government, filing grievances against the government, but they can't be forced to pay for political expenses unrelated to those type of activities. So that would violate the First Amendment. So it was slightly better what the Michigan Supreme Court did, but still, it upheld the core system. However,
couldn't that be seen as a loss for the unions in some way? I mean, they were able to force people to pay membership dues, 100% of membership dues up until that time. And then Abood changed it so that they could no longer get 100% of union dues out of at least some people, the objectors. So yeah. Did unions at the time see that as a loss for them?
I'm not sure exactly how they viewed it. It was a slight setback to them. They got 80% of what they wanted. So, they had 100% before, and they walked out the door with 80%, because usually compulsory union fees after Abood, between 80 and 90%, depends on the union. So, they lost a little bit of what they had before, but not a whole lot. They still got the bulk of sort of what they wanted. But going back to Abood, their concurring opinion in Abood said that this doesn't make any sense. And the main reason was there is no difference in the public sector between collectively bargaining with the government and lobbying the government. They're both political activities. And so this distinction drawn in Abood doesn't make any sense. It's based on this idea that somehow collectively bargaining with the government isn't a political activity. But of course, bargaining with the government's the epitome, of a political activity. I mean, under the text of the First Amendment, it's literally petitioning the government for a redress of grievances. And so this line drawn in Abood, which they took from the private sector, didn't make any sense in the public sector. But, the The law is what the Supreme Court says it is. And so that was the line the Supreme Court drew in 1977, and one that was stuck with for the next 40 years.
Makes sense. And at least as I read Abood, there was some prophecy within Abood itself about the problems that might be created with this line drawing. That's the way I read it anyway. I pulled out a quote. The court said, "We do not hold that a union cannot constitutionally spend funds for the expression of political views on behalf of political candidates or toward the advancement of other ideological causes not germane to its duties as collective bargaining representative. Rather, the Constitution requires only that such expenditures be financed from charges, dues, or assessments paid by employees who do not object to advancing those ideas." Skipping forward. "There will, of course, be difficult problems in drawing lines between collective bargaining activities for which contributions may be compelled and ideological activities unrelated to collective bargaining for which such compulsion is prohibited." Did that come about? Did that come true? Was that prophecy accurate?
Oh, yes. The Supreme Court in Janus, when they overruled Abood, to jump ahead of the story, relied upon the unworkability of the framework. I mean, conceptually, Abood's framework makes no sense for the reason I just said. But even under that framework, how do you separate the wheat from the chaff? How do you distinguish which expense, like in terms of like individuals spending their time, union business agents, every little expense, how do you exactly categorize that? How do you protect employees from being overcharged? And after Abood, you basically had 40 some years of litigation over line drawing, both in terms of how do you define what's chargeable and not chargeable when you get down to the details, and also procedurally, how do you work this system? There's a lot of litigation at the right to work. That's sort of our bread and butter, for almost 40 years of litigating those kind of cases of exactly what can be charged and how.
So what did those cases look like? I mean, I don't know if you've got a ready-made decision you can remember where you represented someone who was challenging the chargeability of certain items. Do you recall? Were you involved in any of that?
So on what we used to call chargeability cases, on what's chargeable or not, two reached the Supreme Court after Abood. One was called Leonard, the other called Ellis, each one of which involved, I think, 6 different categories of type of expenses where the court had to decide, is it chargeable or not chargeable? So, for example, in Ellis, is union organizing chargeable? They're trying to recruit more members. When we did all the Supreme Court said no, recruiting is outside of that, but the union said it was because if you recruit more members, you're stronger in bargaining. There were questions about death benefits in one of the cases. Leonard involved lobbying, and in the court drew even the finer line in that. In Leonard, they said, well, you generally can't charge for lobbying unless it's to ratify or fund the collective bargaining agreement. Then it's fine, because that's like it. So even within that narrow world of lobbying, however defined, they split on that. And Leonard wasn't even a non-unanimous majority opinion. It was 4-4-1.
Oh, wow.
So the Supreme Court would never actually came to a complete agreement on what's chargeable, what's not.
So what happens when, for instance, the teachers union goes to before Janus went to the state legislature? So, normally they sit at the bargaining table and they're trying to get a deal done with the school board, but instead they go do an end around and go to the state legislature and try to get a bill to say limit class sizes, something like that. Was that chargeable under that regime or non-chargeable?
In my opinion, it would be non-chargeable. However, you could probably find court opinions suggesting the opposite. The Ninth Circuit's decision in Knox, which was ultimately overturned by the Supreme Court, they said union participation in a ballot initiative that would have affected issues of collective bargaining, that was chargeable to them.
Chargeable meaning that they could charge it to non-members who otherwise object to union political activity.
Yes. Yeah, chargeable. It's if you're a non-member, you don't want to support the union, what can you be forced to pay for? What's chargeable and what you can't be was called non-chargeable. And this, by the way, we're not just talking about history, it doesn't exist anymore. In the private sector, this dichotomy still exists. So if you're a private sector employee listening to this in a non-right to work state, this still applies to you. It doesn't apply to the public sector anymore because of Janus. But this isn't just, sort of historical in terms of what we're talking about.
Well, let's do skip forward. Skipping forward quite a ways to 2018. The Janus case, on which you served as lead counsel, and National Right to Work was involved in that case alongside a state group, Liberty Justice Center. Janus. Why don't you start with maybe what the best union argument was leading up to Janus for keeping this regime in spite of some of the unworkability problems that we just discussed?
Sure. The main union argument, at Janus was stare decisis. That's the idea that the Supreme Court doesn't overrule its precedents unless it has a really good reason for so doing. Like why you need this sort of very, not extraordinary, but a high bar reason for the court to diverge to what it did before, even if the court thinks it's wrong. And stare decisis is important because you don't want the courts going all over the place. That's sort of the bedrock of our legal system, or at least the common law part of it. But with constitutional cases, only the Supreme Court can fix its problems. And so the union's main argument was, Abu's been the law of the land for a while. Don't upset the apple cart. Stare decisis. In terms of their more direct argument for compulsory fees, it's what's called the free rider argument. The unions argue, we have a legal duty to represent these non-members in collective bargaining. Therefore, we should be able to force them to pay for it. They shouldn't free ride on what they're entitled to. So that was the argument. And they still use that argument in the private sector. The argument has a whole lot of flaws. The first of which, free rider is not quite the right word. It's more would be forced rider. It's the union that forces these non-members to accept the union's representation. And so for the union to then turn around and say, we're entitled, to payment for our services, it's the union that forced their services upon them. And it just is a very basic common law matter. You can't do that. You can't force your neighbor to accept a service and then say, now you owe me money. Like if you came home, from work today and also your neighbor mowed your lawn, he can't say you owe me $20. Like if you didn't ask him to do it, he just can't force a service on you, whether you like it or not. And the other problem, of course, is that it should be up to each individual to decide whether or not they think union representation is worth paying for. If an individual thinks it's worthwhile, they could pay for it. Just as any other kind of voluntary organization. But if you don't think it's worthwhile, you can't be forced to pay for it. And, a lot of organizations, their advocacy could arguably benefit others, but you can't force them all to pay for it. The AARP would probably argue that its advocacy benefits all senior citizens, but the AARP can't force everybody over the age of 65, to kick in money, for their political advocacy.
Now, if I'm a union representative, I want to draw a distinction between AARP and the kinds of services that we provide as a union. I think, I'd argue, again, as a union representative, that I basically have to provide these services because at least a majority of the union, the membership, has supported my existence. And therefore, because I'm obligated to provide these services, I can't simply go without payment for them. Otherwise the union is going to be weak and ultimately might fall apart. How do you respond to that?
Well, the counter argument is the union is not obligated to be an exclusive representative. It's the unions that choose that power. And I think that's a very important, aspect to remember about exclusive representation. Something that the Supreme Court picked up in Janus is exclusive representation is an incredible power for unions. It has an incredible benefit. It gives the unions the power to speak for everyone in a bargaining unit, whether they like it or not, which gives them a whole lot more leverage than they otherwise would have. It also gives unions the power to force the government to actually deal with them. Normally, a private employer, a public employer could say, we can choose to who we listen to. Not under a regime of exclusive representation, they have to listen to the union. And this exclusive representative power allows unions to get all kinds of perks and benefits for themselves and their benefit, their officials that they otherwise wouldn't be able to get, like official time for acting as union officials, payments being made to union pension plans and things like that. So exclusive representation is this incredible benefit and power to the union. And for them to turn around and say, this is a horrible burden we should be paid for, is nonsense. It's like somebody seizing the crown and then complaining about how heavy it is on their head.
Now, we'll get to Janus in a second, but first, does that argument hold even if, let's say, the union loses 90% of its membership because they're all assuming that they can free ride? Like a church congregation, and the the tithing plate just keeps moving because everyone's hoping they get the benefits of church membership without having to pay for it. Does it hold with 90-10 or 95-5? Does the union still get to? Is the union still able to operate under those kinds of conditions?
Well, I'd say to the extent that the union can, that's just a reflection of what individuals choose. If no one wants to support the union, that says a lot about the union, that people don't want to support it. They don't think it's worthwhile. And that's true of any organization. Any voluntary organization, which basically excludes private sector unions, of that. If people don't want to support it, it means you're not offering a service they think is worthwhile. So if 90% of people don't want to pay the union and don't think they're worth it, maybe the union shouldn't be in power anymore, which is another huge problem with labor law of unions being able to maintain this monopoly bargaining power, even if employees don't support it. Because the law gives the unions that power, it makes it exceedingly difficult for employees to decertify, even if most of them want to do it. So, I think a problem where you have a union representing, employees and 90% want nothing to do with the union, there's a problem there. It's not that employees aren't paying union dues.
Yeah, we've actually seen at Commonwealth Foundation, we're looking into some what you call union membership density numbers in different state governments. How many state employees are members of a union, not just unionized, but actually members of the union. And in Florida and maybe one other state, that number actually drops below 50%. Yeah. So I suppose the mechanism that you'd suggest is if membership is falling that low, somebody should revoke the certification for the union if the union doesn't just voluntarily relinquish it because they're unable to provide the services.
Which is now the law in Florida. If a union doesn't have a certain percentage of membership at the end of a 3-year period, the union needs to be recertified to show it still has majority support. And if it doesn't, it's decertified. And I think things like that are very needed. A study a few years ago found is either 91 or 93% of union represented employees have never voted on union representation. Not for it, not against it, not ever. Because an unfortunate part of most labor law, other than Florida, which is more recent, once a union's certified, it's in forever, unless you can decertify it down the road. And so sometimes unions came into power in votes in 1970s. There's no one left alive, no one left employed at the workplace who ever voted on whether they want the union. It's just the union is just sort of part of the woodwork. You see that in both the private sector and public sector. So a lot of places that have long been unionized, there might be nobody there who's ever had a choice, or an opportunity to vote on whether they want the union to represent them.
Now, I'm not sure that any of that changed in Janus, right? But Janus, if you could tell us what Janus did with Abood and the problems that followed Abood around line drawing.
Sure. So just say what happened in Janus, the bottom line of it, Janus overruled Abood. It basically said Abood is no longer good law. And then the court went on to say compulsory unionism clauses, at least when the government enforces them in the public sector, are unconstitutional. It violates the First Amendment for the government and a union to force any employee to pay union dues or fees to keep their job with the government. So that's sort of the bottom line of what Abood did, which, is significant. By our calculations, Janus freed about 5 million, some public sector employees from being forced to pay union dues. Now, some, of course, still wanted to continue to stay in the union. That's fine, as long as it's a voluntary free choice. But that's ultimately what Janus did in overruling Abood, is making it unconstitutional to force employees to pay union dues to keep their jobs. In terms of the Janus's rationales, there were a number of them, but the one of them that you alluded to is that Abood was unworkable. Conceptually, distinguishing political expenses from collective bargaining with the government didn't exist. It doesn't make any sense conceptually. But even beyond that, it was extremely hard to separate the two. And there was the court cited back to Leonard, this decision. I said that even then they couldn't figure out exactly where to draw the lines. We also used examples in the case of how hard it was for a non-member to even determine whether they were being overcharged. Part of the Abood regime we didn't talk about was that in order to force a non-member to pay dues, the Supreme Court ruled in a case called Hudson that the union had to provide the non-member with a financial notice so that non-member could, get an idea of, well, am I being charged or overcharged? It never worked. Especially of these large unions, these huge payrolls, that alone, the non-member had very little ability to see, am I being overcharged or not, based upon that. So anyways, Janus found that Aboud's regime was unworkable, and that was one of the many reasons the court struck it down.
Now, one thing I don't think we talked about with Aboud is the concept of labor peace. So if I was trying to explain Aboud to anybody, I might say something like, look, there are important First Amendment rights of public employees, but sometimes, we compromise, but we always have to compromise for good reason. And strict scrutiny makes that even more difficult for the government to justify. But whatever level of scrutiny they applied in Aboud, I would have thought that the chief reason was something they called labor peace, which I guess is, people kind of getting along at work, and unions and rival unions not fighting over members, no strikes, something like that. How did the labor peace argument, how did the court deal with the labor peace argument in Janus?
Effectively, the court found it wasn't enough to justify compulsory union fees, because the labor peace rationale, for better or for worse, isn't a justification for compulsory union fees. It's a justification for monopoly union representation. So monopoly union representation, exclusive representation, is this idea that the union represents everyone in the workplace and there can be no other union, hence the term exclusive. There's one monopoly, one representative that's monopoly on representation. The justification for that is a so-called labor peace rationale. The government has an interest in having only one representative because it'd be a real pain to have to deal with more than one. There's all kinds of flaws to that, but we'll put that aside for a second. But what the court said is, well, even if you accept that labor peace justifies exclusive representation, that doesn't mean you need compulsory fees. And what the court looked at, it said, you have exclusive representation all over the place in right-to-work states. There's all kinds of states where, including right now, that you never had compulsory fees, yet you have exclusive representation. Easy examples of federal government. Federal employees, of course, are unionized. There's the Federal Labor Relations Act. They've never had compulsory fees, yet they have monopoly representation. So the court was easily able to say, whatever the strength of labor peace, it doesn't justify fees. At most, it justifies exclusive representation, and that, wasn't the issue directly before the court.
Got it. Okay. Well, so as you went in to argue this case, I'm curious, was there a particular argument that you felt you had to make in order to convince one or more justices to abandon Aboud for one reason or another?
I think at the time, the arguments about originalism, I think, were most prominent. And this requires to go back a little bit in history of the litigation. In a case called Harris versus Quinn in 2014, which I had the honor of arguing, the issue there was whether or not you could force individuals who weren't full public employees but were independent Medicaid providers who received Medicaid payments to pay compulsory union fees. Essentially, unions in the state of Illinois tried to expand Aboud to beyond public employees to anybody who gets public money. And so the issue there was that unconstitutional? The justice says, yes, that's unconstitutional. And in the Harris opinion, they basically tore apart Aboud. They went chapter and verse of all the reasons Aboud's wrong. But they said, but we don't need to overrule it here because these aren't full public employees. Just letting you know, we think Aboud should be overruled. And they found, it could be extended to these independent providers. Then a case came after that called Friedrichs. Friedrichs involved public employees. It looked like the same vote was going to come that came in Harris, but this time they were going to overrule Aboud. But after Friedrichs was argued, Justice Scalia unexpectedly passed away. So that left the court deadlocked 4-4. Friedrichs was dismissed after that. And so the next justice who was appointed to replace Justice Scalia was Justice Gorsuch. At this point, Janus reaches the court. So the background of all this is that all the justices, except for Justice Gorsuch, have pretty much already voted on what they thought about Aboud in both Harris versus Quinn and likely in Friedrichs. Because when Friedrichs was dismissed, it was dismissed 4-4. So really, most attorneys believed that Justice Gorsuch was probably the swing vote. So I guarantee.
I've forgotten that they already argued Friedrichs by the time that you got up there. So in a sense, you had seen a simulation of what you were going to experience, with the caveat that Justice Gorsuch would be up there for the first time.
Yes, twice. It was the first round. Friedrichs was sort of the second argument on it. And again, they split 4-4. So that showed that 4 justices minus Justice Scalia, probably wanted to overrule Aboud. Now again, they could have gone somewhere in between. It wasn't like either you overrule a boot 100% or you don't. There were some arguably middle grounds. I don't think there were, but you can't guarantee it at the time, knowing what you knew. But going into Janus, I think it was rather clear that Justice Gorsuch would probably be the swing vote on this, because the other justices had already seen this twice and voted on it. What they thought. And this is reflected actually in the unions and states' briefs. All of a sudden, unlike the prior cases, their briefs were all about originalism, from beginning to end, because Justice Gorsuch is a well-known originalist. So that was sort of the new twist in the case. The unions never argued originalism before, but now all of a sudden, compulsory unionism somehow baked into the Declaration of Independence. Just sort of funny. But anyways, that's what they had to go with. So it was the originalism arguments that I was sort of very sort of teed up on, because the rest we sort of already had seen before to a large degree. But really, in the oral argument, at least, it didn't come up. Justice Gorsuch didn't ask a question of either side. And so that was what I was most prepared for. That was different than what I was prepared for before. And just for your reader or listeners, rather, the Janus opinion did address the originalism argument and said there's no history of compulsory unionism anywhere, going back, that you can sort of rest this on to say, oh, it was common, when the Constitution and Bill of Rights was put there, or even when the 14th Amendment was put in. This is an entirely new thing. And in fact, it was very well established that you couldn't condition, public employment on some kind of thing. It was actually in, what was the precursor to the Bill of Rights in Virginia? The Virginia Declaration of Rights. Thomas Jefferson wrote it. Anyway,
something like that. Yeah.
Yeah, but there's a provision in there about how public servants shouldn't be forced to swear oaths and things to that effect in order to be public servants. So from the very beginning, you sort of had a record of, you can't make people betray their convictions in order to serve the government. So in any case, the originalism was the more interesting change in Janus.
Now, post-Janus, after it's been decided, it's been, 5, almost 6 years now. What's the practical importance of that case for public employees today? I mean, has it changed their lives in any important respect?
I think it's changed the lives of those who, don't want to join or support a union. I mean, I said if you exclude right-to-work states that have statutory prohibitions on compulsory unionism, there's about 5 million some employees in states that used to allow forced unionism. Those employees and all those employees in the future now, will have the right to choose whether or not they want to join or support a union. Now, for people who want to join the union, I guess who cares? At least if they want to join it right now. But for individuals who don't want to support this special interest group, I think Janus, is very important. It vindicates their core First Amendment right to choose which speech they want to support. Because it is a core right. I mean, all of us have the right to choose which political party, if any, we want to support, which political advocacy groups you want to support. It sort of goes across the board, but you always have this anomaly for unions. That unions is this one entity that you could be forced to support for purposes of lobbying the government. So Janus eliminated, that anomaly. And as a result, public employees, now have this right to choose. Hopefully all private sector employees one day will also have that right. And it's something, we're working towards the right to work.
And to what degree have unions actually respected that right? So a lot of these maybe an orientation meeting or a recruitment meeting might happen outside of earshot, behind closed doors. Are you convinced that unions are following the law when it comes to Janus?
They're trying to frustrate it, I'd say. The vast majority of unions, if somebody is a non-member, never signed anything, they've given up on trying to force them to pay union dues because it's just so blatantly unconstitutional. Almost overnight after Janus, it was so unequivocal. Compulsory union requirements stopped across the board. But the primary thing unions and their government allies have been trying to do is cajole employees to sign dues deduction cards that have windows on when they can be revoked. So, for example, it would say, I hereby agree to allow the government to deduct union dues from my wages, and I can only revoke this authorization once per year during one 10-day period. And if I don't revoke it, I pay for another year. And so what they're trying to do is get individuals to waive their rights under Janus to stop paying union dues. And so, as you mentioned earlier, one tactic they use to get employees to sign these are these mandatory orientations. They force all new hires to attend a 30-minute meeting with the union, where the union basically tells me, yeah, you got to sign this. And then once they do, all of a sudden the union says, you've just locked yourself in, to a year paying union dues. So there's been a lot of litigation trying to challenge these attempts to sort of restrict employees' rights to exercise, ability to exercise their rights under Janus.
How do they justify these kinds of tricky, let's say at the very least, they're like tricky marketing mechanisms. At the most, there's some kind of a First Amendment coercion, how do they justify being able to do these activities without violating Janus?
So their legal argument for it, there's really no policy justification for it. They're just trying to lock people in, as far as their legal justification, say, well, it's a contract. The person contractually agreed to it. You're locked in. And there you go. So that's sort of what they're relying on. We think that those type of restrictions should be subject to a higher standard. That the union should have to prove employees waive their First Amendment rights, which is much more difficult to prove because, among other things, you have to show employees were notified of their First Amendment rights and knowingly chose to waive them. And of course, unions don't tell employees they have a First Amendment right not to pay union dues. They just sort of say, hey, you should sign this card. Here you go. And then all of a sudden the employee is locked in. And it's really, a bit of a travesty because this would be illegal in the consumer market. If a company selling, some sort of subscription product said, once you sign up to pay for this product, you can only revoke it during one 10-day period per year. Otherwise, you're locked in. You would have consumer, type laws coming right down on top of them, saying that's, an illegal business practice. But unions and their government allies in certain states like to do it for the simple fact the more people pay union dues, the more money that goes to unions, the more money that goes to their political allies. It's just sort of a political, type of corruption.
Yeah. Well, it reminds me of those. I used to get these Time books, real expensive, beautiful books in the mail from Time. And there was something they ended up calling negative option. You had the option to keep it, but you'll have to pay. If you choose not to exercise that option, then you have to mail it back. And suddenly that burden is on you to object. So, I understand what you're saying. This does remind me in some sense of the union making it difficult on people, to get out and putting the burden on them of figuring out how and when they might get out of what they're calling a contract.
Yeah. In the window period, there's really no justification. So again, some of them say, in order to cancel this, you need to provide notice within a 10-day window. So that means if you gave them notice 15 days before that, it's no good. They'll ignore it. And say, you told us too early. Why? Why is there any legitimate justification whatsoever to tell somebody you can't give more advance notice of cancellation? That you can only give notice of cancellation between December 10 and 20. But if you tell them on December 5th, that's invalid. It's a complete trap. Sort of should be considered unconscionable, but so far, the unions are getting away with it in many states. And it's something, that we continue to litigate over.
The time scheme has since been made illegal, or at least they've applied the law to state that it is illegal, and it no longer happens. I don't get those magazines anymore.
Yeah. And the funny thing is, the states with the strongest laws against negative option contracts are generally the ones who are most amenable to allowing unions to force employees, into these type of negative option agreements. So very different standard for consumers than for unions.
Last question. To the degree, a state wants to do something about this, or a legislator, or maybe even a local government official wants to do something about this to end some of these tricky workarounds, to what degree can they do that? Have there been any successes in states since Janus?
So the simplest system is to eliminate government payroll deductions, which is what the state of Florida recently did. Other states have done it. And it's just, why is the government acting as the money collector for big labor? There's no reason for it. If the unions want to collect money from individuals, they can collect it just like any other private organization does, from the Sierra Club to, whoever. But the unions are one of the few that the government acts not only as their collection agency, but also as their enforcer of not allowing individuals to stop these deductions except during these 10-day windows. So the best reform is just get rid of government payroll deduction. Let unions collect money from individuals, by check, credit card, whatever, just like you pay for anything else. And the nice thing is, because that's more of a consumer transaction, it's very difficult to put restrictions on stopping that. Just like right now, if you have an automatic deduction off your credit card for some sort of thing, you can say, hey, stop. You can cancel it. But when the government's sucking money out of your paycheck for a union, there's nothing you can do to stop it other than to quit your job. So the best reform, at the state level with respect to the union dues issue is eliminate payroll deduction entirely. The second best would be to reform the payroll deduction system to make clear that these authorizations are revocable at will. And that employees are notified of their rights. The state of Indiana has done that with public school teachers. Of course, unions have challenged it. So the state of Indiana basically said, in order to deduct dues, you have to give notice to these employees so they know they have a right not to do it, and it's revocable at any time. Lo and behold, the unions have sued the state of Indiana, trying to strike down that law because it interferes with their ability to take money from people who obviously are either misinformed or want out. But for the unions, it's just, a question of how much money can they extract, not about, individual freedom.
All right. Well, Bill, thanks for taking some time with us today. Appreciate it.
Of course. Thank you. It was a pleasure.
And that's a wrap for today's episode of Disunion, the Government Union Report. We hope you found today's exploration into public sector labor policy both insightful and thought-provoking. Special thanks to all of you for tuning in. If you enjoyed today's discussion and want to stay informed about the latest developments, don't forget to subscribe to Disunion, the Government Union Report, on Spotify or your favorite podcast platform. Your support means the world to us. I'm David R. Osborne, reminding you that understanding labor policy is crucial for shaping the future. Until next time, stay informed, stay engaged, and keep making a difference.